Today, the Insider Exclusive goes behind the headlines in The Smoking Gun, Jayleen Munoz's story, to examine how John Fisher at John H. Fisher PC and Joseph O'Connor, partner at Mainetti O'Connor, successfully represented Keneitra Munoz's family in a very challenging case. Challenging because the defendant's Service Employees International Union failed to provide the most incriminating evidence during the initial court-ordered discovery process. But because of John Fisher and Joe O'Connor's continued and persistent intensive investigation, they discovered this hidden evidence which turned out to be the real smoking gun, resulting in legal and moral justice for their client. The smoking gun in this case was the discovery of 3 key critical documents which provided compelling evidence showing the health and safety hazards that the Service Employees International Union employees faced on a daily basis, resulting in this catastrophic car accident. John Fisher and Joseph O'Connor have earned the highest respect from citizens and lawyers alike as some of the best trial lawyers in New York and in the nation. They have seen many innocent and hardworking people become victims in catastrophic accidents, and because of that, they are driven to fight for people who have been harmed by the willful or negligent actions of others. Their amazing courtroom skills and headline-grabbing success rate continue to provide their clients with the results they need and the results they deserve. This is the Insider Exclusive, live from Kingston, New York. It is my great pleasure to introduce John Fisher and Joe O'Connor to the show. Welcome to the show, guys.
Thank you.
Thank you.
Joe, tell our audience a little bit about your firm. What type of law do you practice?
Sure. Our firm is in Kingston, New York. We practice throughout New York State. The type of matters we handle are construction site accidents, motor vehicle accidents, motorcycle accidents, and what we would call premises liability accidents. Accidents where someone is injured due to a defect on someone's property.
Right.
They're mainly the type of matters that we handle at our firm.
And generally, you always represent the individuals.
We always represent the injured persons.
Okay.
We don't represent insurance companies. We don't represent defendants. We represent persons who are injured and sometimes catastrophically injured people.
What about your firm, John?
Just complex catastrophic litigation, anything that no other attorney in the world wants to handle because it's too complex, too expensive, and the issues are just way beyond the other attorney. So the typical example would be a medical malpractice case involving a brain-damaged baby, where the expenses could run $100,000, $200,000. There are going to be a boatload of experts on the case, and the attorney basically just wants to ship it off, get a piece of the referral fee at the end of the case, and just leave it up to me. And that's basically what I do, cases that no other attorney wants.
Yeah, and I do want to make known to the public that your firms, when you take on a case, that you do so on a contingency basis. The client doesn't have to pay any money. If you win the case for the client, then you get paid. If you don't, then you're out. So you really evaluate cases very carefully before you take them on, right?
Certainly.
Today we are here talking about the Jayleen Munoz case. And would you tell our audience a little bit about who Jayleen is?
We got a call, my partner and I, Al Mainetti, one night from Jayleen's mom, Keneitra. She said she had hired a law firm. She wasn't happy with what was going on. She had a very severely brain-injured daughter who was injured in a motor vehicle accident. We met Jayleen for the first time that night. We went to her house immediately, both my partner and I, and we saw a little girl who was all smiles, but was obviously brain injured. She had a helmet on, little flowers attached to the helmet, and from that moment on, we dug into that case because it was such a wonderful person who had been so seriously and traumatically injured.
What happened to Jayleen medically?
Well, Jayleen was a backseat passenger in a vehicle, and she had a bleed in her brain called a subarachnoid hemorrhage. The right part of her skull was shattered, and she was in the worst of worst situations, she had an emergency operation on her skull on the same day of the operation, and she had a long rehabilitation period where she was sort of like a stroke victim. She had to learn how to walk. She wore a helmet on her head, and it was about a year before she could have any normalcy at all to her life.
Tell us a little bit about why this case was unique and who the defendants were.
Well, I guess in the beginning when we took on the case, we received an accident report, as we do in all cases, and it lists one defendant driver, the person who rear-ended our client's vehicle. As the case developed, what we did, and I think it was a step we took that maybe the other firm didn't look into, we went into the DMV records and found that the vehicle was owned by a person who had substantial insurance coverage herself. So we proceeded to put the case in suit, start depositions, question anyone and everybody who was involved or saw the accident. It came about that we determined that the driver was working for a union, the SEIU,
which is
one of the biggest unions in the world, certainly one of the biggest in the United States.
Which is the Service Employees
International Union,
right.
Yes. And there was a dispute during the litigation as to whether that person was in his employment, and that really became the battle of the entire case.
And how did you find out that they were in their employment? In other words, when they were driving their car, they were working in the capacity of their job. How did you find that out?
During the deposition, there were some vague comments that the defendant, Mr. Nembard in this case, had come from a barbecue involving the recruitment of union persons.
Yes.
It was unclear. He wasn't quite specific. After that, I think the case was really established once John and myself and our investigative team were able to get to the persons who were at that barbecue. And that involved traveling extensively into Connecticut and tracking down all of these persons, most of them who were not legally in the country and were of Haitian descent, into their communities, getting these people to speak to us and getting these people to give us sworn statements as to the fact that Mr. Nembard was there not just to drink and have something to eat, but was there to recruit them as potential union people.
What we liked the most about this particular case was not only you successfully settled the case, won the case, but also you did some really good detective work, because what the audience is going to know right now is this case was originally dismissed, wasn't it?
Well, it was dismissed, actually, not originally, but it was dismissed after all of the discovery was done, all the depositions. We were on the verge of the first trial when the court dismissed it outright. It was stunning. Joe got the papers. He brought it into my office and said, "You're not going to believe this. The case has been thrown out by the judge." We had to basically adjourn the trial because at that point the Service International Employees Union was out of the case, and a co-defendant was out as well. We basically had one defendant left. We appealed it. About 6 months later, the appellate court overturned the dismissal.
And tell us why they overturned it, because this, you mentioned a thing, you basically had all the discovery, but you really didn't, did you?
No, not at all, because what had happened was we got little bits and pieces of the names of these witnesses. We went to their homes, we interviewed them, but all of this stuff was happening right about the time that the case was dismissed, so we didn't have everything. And by the time of the appeal, and we had added this new information, witness statements, we submitted it. The court then reversed and held that the lower court had made the wrong decision and reinstated the case.
Now, there were 3 missing documents, weren't there, Joe?
The missing documents
that were significant.
Well, there was some discovery that we thought should have been turned over. And when we're referring to, there was a report from the SEIU about the dangers of driving and driving late and late hours. We were able to obtain that after months and months of interviews of union persons. There's a union that represented the union. And eventually we found a safety person who wrote an extensive article on behalf of, who was hired by the SEIU, and it detailed exactly the understanding that they knew their union organizers were putting people at risk because of their hours.
And putting them at risk, they used to require them to drive how many miles?
There was no requirement of how much they had to drive, but they were required to use their own vehicles. They were required to use them if it was within 1,000 miles of their local base. They were required to attend these events late at night. They were required to work through weekends and 7 days straight every other week. The extensive information that we found out about the union went much beyond that.
Yeah.
That this was not only was it appropriate, which was one of the defenses, he shouldn't have been at a barbecue. It was appropriate, but that they asked these union organizers to go much above and beyond that type of behavior,
right,
in attempting to unionize these organizations.
By the way, as a result of this case, the union can no longer require their representatives to drive more than what? Well, they work more than 8 hours a day.
That's what they were trying to do. Here's the interesting part of this. There had been an occupational hazard report that was issued the same month of the car accident in May of 2008 that stated that the union organizers at this union were exceeding all the allowable driving hours in their job, and that they should be limited in the number of hours per day that they're allowed to drive. Now, that report was ignored. It was never implemented. Any of the policies that were recommended were totally ignored. So the union's hiring an occupational hazard but ignoring the report that they had. And that's what this case was really about, a union that was putting its own workers in safety while ostensibly acting in favor of protecting the rights of workers.
Okay. Now, there was also a dispute on the life care plan amount of money. Is that right?
There was a dispute. I think both...
And explain for our audience what that means.
The life care plan projects the life care costs over...
Of the injured person.
Over our injured person, who was 2 years old at the time of the accident, over her lifetime. It projects also, to the extent, there was also a projection of lost income. The issue here, both experts, the union hired and our expert, said it would be significant. Our life care plan, the projections were very close to $70 million of medical treatment over her lifetime.
By the way, we're showing these plans as you're talking.
Their expert, her plan was probably closer to $20 or $30 million.
Substantially less.
But substantially less, and we didn't think they could justify it. Jayleen is someone who is going to need treatment and will never be able to live independently for the rest of her life.
What were some of the flaws in the union's projection of the life care plan?
The flaws of the plan were basically they were projecting in current day, present day numbers. So in other words, they're saying currently it will cost about $5 million to take care of this child for the rest of her life. They didn't project the future increase in costs of medical expenses, the impact of inflation, any of that. When you add all that stuff in, it brings it to about $20 to $30 million.
Right. Now, you settled the case for?
$7 million.
Okay.
So that number was one of the biggest recoveries, certainly in the Hudson Valley. And it came when the original offer to settle this case before we were involved was $25,000 or $50,000. It's unclear. That was made to Jayleen and her mom before they made that phone call.
And this is one of the reasons why we do these stories, is because when you do the right kind of homework, when you really pursue the interest of your clients, you can try to get as much justice in terms of dollars and cents to take care of this young lady for the rest of her life, which is what's needed, right?
Yeah, I think what really had to be done in this case, and more than any other case I've handled, we had to get witnesses that were not willing to cooperate. We talked about the persons who were at the barbecue who would confirm that this was union activity.
Yes.
Not only that, I know John and myself, we went to Connecticut at least 12 times between us. We did depositions and questioned persons in Ohio. John flew to the West Coast and met with this person who wrote the occupational report. He also went to Washington, D.C. and met with a former vice president, someone who's retired from the SEIU, and got that person to cooperate against all opposition from the union. And those efforts to go to get these witnesses, to go, in fact, we went to Florida to meet with another person who was an SEIU employee. That's what got the $7 million. Those efforts to get those witnesses and then get them to cooperate, especially the persons of Haitian descent were not willing to talk about union, or they were even involved in union activities.
They didn't want to lose their jobs. They didn't want to be retaliated
Correct.
against. Well, congratulations on this successful settlement. That's a substantial amount of money, and far more than what the other law firm would have been able to get for them. We also have someone who played a major part in this case with us today, Al Mainetti, who is the founding partner of your firm. So let's bring on Al right now. It is my great pleasure to introduce Al Mainetti to the show. Welcome to the show, Al.
Pleasure to be here.
Tell our audience a little bit about personal injury lawsuits, because there's folks out there that may have been injured. They just don't know. They've never been to a lawyer. A lot of your clients have never been in contact with a lawyer before until they have to be, right?
true. A personal injury lawsuit involves, excuse me, involves a client who's been injured in some type of accident or traumatic event. We look at the event, look at the client's fact situation, decide if there's liability. There has to be somebody at fault that caused the injury through negligence or error. And if there is, we pursue that person at fault for the injuries caused to our client. We seek a sum of money for the loss of quality of life, for that injury, for the fact that our client is going to have to live the rest of his life, perhaps, depending on the injury, with this disability from that event.
Now, since most of your clients who come to you have never been involved with a lawyer or a law firm before, and you'd have to say the majority of them, right?
Sure.
They don't know anything about how a law firm works or whatever. When you take on a case, how much does the client have to pay you?
We take all of our personal injury cases on a contingency, so there is no fee unless we are successful. If we come, you don't have a case, we investigate it, we spend our monies to determine that there may be no case, you don't pay a fee. If we're successful, then we get paid on the case. And that's how it works, and I think that protects the clients, and that gives them an opportunity to take on insurance companies, corporations, because they've got an attorney who's willing to take on the case on a contingency and make a determination whether they want the case. But there is no cost to the client.
Right. Al, typically, how long does a case last?
Typically in Ulster County, a year and 4 months to about a year and 8 months.
To successfully wrap up a case?
From beginning to end.
Okay.
If you go to trial.
What type of cases are you taking on right now, generally?
We take on any type of injury case, but we prefer to take cases which have substantial injury.
Are there cases that you, Joe, for example, find yourself leaning more to because you have more of a specialty with that?
I wouldn't say specialty, but we find ourselves, we represent a lot of motorcyclists and workers, construction workers. In New York State, we have what's called the labor law, Section 240, and we represent a lot of blue-collar people, the motorcyclists, people who are injured in car accidents, and the construction workers. In New York State, it's one of the few states that has special protections for persons who work at an elevated risk. And when we look at our caseload each and every year, those are the type of cases that we handle, and those are some of the much more serious cases where there's tremendous injuries from falls from great heights, referring to the construction cases. And the same with motorcycles. The motorcycle cases, you'll find, we're seeing more and more of those cases. Cars are safe. There really isn't anything to make a motorcycle safe. And we've seen a huge influx of motorcycle cases over the last 5 or 10 years.
Why is that? Because more people are riding motorcycles?
I don't know some of the numbers. They're about the same. I just think that the type of cases, you'll see a collision.
These are accident cases.
Correct. You'll see a collision between two cars and everyone will get out safe because of the safety, which is great. The safety, the airbags, the collision and the testing of those vehicles. But on the motorcycle cases, there's nothing to protect a motorcyclist. And when someone's falling from a height at a construction site, there's nothing to protect them either if the safety devices aren't provided for them.
In the state of New York, you brought up that you have special protections for construction workers. What are they, as opposed to other states?
The labor law, 240 of the labor law, is the special protection. And basically it puts liability on the general contractor, the owner of the property for commercial jobs.
Yeah.
And what that means is that you can have a subcontractor who, say, your client is working for. That particular subcontractor may have very limited assets, and your client who's fallen from a scaffold or from a ladder has very significant injuries. But the law in New York, which is one of the few states that still has this protection, in New York, the general contractor and the owner of the commercial property have liability for that injury. It puts great burden on the owner and the general contractor to protect the worker. All the way down the chain at the construction site.
I understand there's some folks in the state legislature that are looking to try to change that, aren't they?
They are. They very
have
much
been
are.
for years, right?
They have been trying for years, and the trial lawyers have been trying desperately to not allow that to happen, to protect the worker in those sites.
When a person, this is to both of you, when a person's been injured, what do you usually find that's going through their mind about whether they have a case or not?
They're really concerned mostly about how am I going to support my family, how am I going to support myself, how am I going to pay my medical bills, what am I going to do in the future. And that's their concern when they come in.
Yeah.
And then you have to decide whether they have a case or not and what type of case it is.
Right.
It could be only a workers' comp case, for instance, in a labor law situation.
I think people are really, it's such a tough economy and they're living paycheck to paycheck. You're injured and you're out for a month or you're out for a year, your life changes dramatically like that.
Right.
Now you've got children, you've got yourself, and you've got to support people, and all of a sudden you can't go to work and your boss isn't going to give you a paycheck for not working, and you've got to make a mortgage payment or a rent payment. I mean, that's usually their first concern. Everyone thinks a personal injury client comes into your office looking for a big payday or a lottery.
Yeah.
They're just looking to get by the next 2 months, 3 months, 4 months, and survive. I mean, that's really, with the clients, when they come in, that's the first thing they're concerned about.
Well, without law firms like your own, these kinds of cases would not be resolved successfully, and these people would not be made whole, if you want to call it whole, or at least get some compensation for the damages and the injuries that they've suffered.
Many times they do not, because sometimes clients come to us and the statute of limitations has to go on their lawsuit.
Yeah. I want to thank both of you for being on the program. You've offered a lot of valuable advice to our audience, and thank you. Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.